All right. Hi, everybody. Thank you so much for being here. My name is Caitlin Kelly. I'm a 1L at Lewis and Clark, dedicated to fighting for farmed animals. And I would like to welcome you to the Fight for Sustainable Food System panel. So our speakers today include Tara Heinzen with the Food and Water Watch, Amy Von Sohn with Center for Food Safety's Portland, Oregon office, Marie Camino with Mercy for Animals, and Erin Sutherland with the Animal Welfare Institute. They'll be discussing the challenges and successes involved with creating and enforcing a sustainable food system for all. Thank you so much for joining us. To everybody watching, please feel free to add your questions to the chat and we'll get to them at the end of the presentations. And without further ado, I would like to welcome our first speaker, Tara Heinzen. So Tara is with the Food and Water Watch's legal director. She has nearly 20 years of experience working with communities impacted by factory farms, including as an attorney, an organizer, and a consultant. Prior to joining FWW as a staff attorney in 2015, Tara spent 5 years as a staff attorney at the Environmental Integrity Project, leading programs focused on factory farm pollution and restoring the Chesapeake Bay. She is based in Portland, Oregon, and graduated cum laude from Lewis and Clark Law School in 2009 with a certificate in environmental and natural resources law. Thank you so much, Tara, and whenever you're ready, feel free to take it away.
Great, thanks so much, Kat. I'm going to share my screen. All right. So thanks so much to the Animal Law Review for having this event and for inviting me. Food and Water Watch, before I get started, works to protect the environment from destructive corporate interests on many fronts, including, most relevant here, a campaign to reform the industrial food system by banning factory farms. So today I'm going to talk about a few of our legal strategies to get the federal Clean Water Act to finally live up to its promise to hold factory farms accountable for their water pollution. Pretty sure this audience doesn't need a lesson on what factory farms are. I'll use that term interchangeably with CAFO, concentrated animal feeding operations. These operations dominate livestock production in the US today. They're getting larger and more prolific. They're also becoming more concentrated in certain communities and watersheds. And they can confine not only hundreds and thousands, but even millions of animals, which means also producing all of those animals' waste, which they then, of course, have to dispose of. So this disposal typically takes place through what's referred to as land application on crops, where it's generally discussed as a beneficial fertilizer. But this is an industrial method of livestock production, and this is not just manure. So in addition to the nitrogen and phosphorus that are usually talked about, this waste stream contains pharmaceuticals given to animals to keep them alive in harsh and unsanitary conditions. It also contains pathogens and can contain antibiotic-resistant pathogens, cleaning products, and heavy metals. So as a result of this method of livestock production, factory farming and agriculture are now a leading source of water pollution across the US. CAFO pollution reaches waterways through many pathways, including over-application on land, application in unsafe conditions like when land is frozen or covered in snow, and also can spill from waste impoundments, as you see here, or they can overflow or breach from storms. The impacts of this pollution include harmful algae blooms, fish kills, dead zones, threats to public health, threats to wildlife, harms to recreation, and dangers to drinking water sources. So that's where the Clean Water Act is supposed to come in. The Clean Water Act, I'm sure most of you are familiar with, but I'll just give a very quick snapshot of how this works. The Clean Water Act prohibits point sources of pollution from discharging pollution into jurisdictional waterways, waters of the US, unless that discharge is in compliance with a National Pollutant Discharge Elimination System, or NPDES permit. NPDES permits operate by restricting discharges of pollutants of concern based on the available pollution control technology, and in some cases, water quality considerations. And they fundamentally rely on self-monitoring and reporting of discharges for accountability. This is usually in the form of what's called a discharge monitoring report, or a DMR. Importantly, CAFOs are defined in the statute itself as point sources. So they should be permitted before they discharge any pollution into a waterway. But it hasn't quite worked out that way. So does the Clean Water Act regulate this industry effectively? Not exactly. I won't go into these court decisions, but a couple of federal appellate cases have limited when EPA can require a CAFO to apply for a NPDES permit. And now EPA basically can only issue a permit when a CAFO is actually discharging. It's a discharge permit, so that might seem fair, but in practice, this has created kind of a catch me if you can system where operators can just say that they're not discharging any pollution and opt out of the permit system. So as a result of this lack of accountability, EPA estimates that only about a third of CAFOs actually have permits now. And that's really a guess. And not only do only a third of these facilities have permits, as I'll discuss later, the permits are pretty weak. So how has this been allowed to happen? There are a lot of reasons, but I'll just touch on a couple that are relevant to what I'll discuss today. First is called the agricultural stormwater exemption. So when Congress said CAFOs are point sources, it also said something called agricultural stormwater is not. Now, those seem like they should be kind of mutually exclusive terms, but EPA has confused things by saying that when a CAFO land applies waste in compliance with nutrient application requirements, any discharge from that land application is agricultural stormwater and outside of the scope of the Clean Water Act. So it's kind of allowed the exception to swallow the rule being CAFOs are point sources. EPA also lacks data on the industry's pollution and has let CAFOs off the hook for the monitoring that, as I mentioned, is one of the cornerstones of the permit program. So with no monitoring, it's really hard to say, I think you're discharging, you need a permit. So the first strategy I'll touch on for what Food and Water Watch is doing about these systemic problems is a petition for rulemaking that we filed with a lot of partners about 5 years ago to overhaul EPA's broken CAFO Clean Water Act regulations. And what we did is really set out a detailed roadmap for how we believe EPA can and should use its authority to ensure that far more CAFOs are permitted and that those permits are far more protective of water quality. And just briefly, some of the top line issues we raised are that EPA should presume factually that certain CAFOs are discharging to require them to get permits. Connected to that is it should revise its definition of the agricultural stormwater exemption so that we don't have that huge loophole and that discharge can be regulated. We also want monitoring requirements in permits and stronger nationwide pollution standards for the industry. So as I said, it's been about 5 years. We're still waiting on a response to our petition, but recent FOIA documents from EPA show that the agency has actually done really extensive analysis of our petition and every issue raised in it. And based on these emails, think that we also have some career staff support, at least for some aspects of our petition inside the agency. Here they're saying, I'm beginning to like this petition and let's not blow it. So we're currently exploring our options to move this strategy forward and certainly want to do that during the current administration. Now, turning to one of our lawsuits, we're trying to make some headway on monitoring of discharges. So the Clean Water Act and EPA's regulations applicable to all NPDES permits say that permits have to contain representative discharge monitoring capable of assuring compliance with permit pollution limits. This self-monitoring, as I've mentioned, is at the core of the permit program, and it's really important to enforcement and accountability. Not only is it important to know if an individual discharger is violating their permit, but DMRs for an industry create critical data about an industry's pollution as a whole, and also whether there's technology that is capable of better controlling discharges. So this information is really important. But as so often happens when it comes to animals and the law, CAFOs are given special treatment and they are treated different from almost every other industry of water polluters. Instead of monitoring, EPA basically assumes that when a CAFO puts practices into place, best practices that are meant to control pollution, that's good enough and they don't need to verify it with monitoring, which we said was contrary to how the act is set up. And so I wanted to talk about this in part just because it fits the theme, I think, of the event in a lesson on perseverance. Food and Water Watch has challenged CAFO statewide general permits 3 times, raising the same fundamental monitoring argument. And first in Maryland and Delaware, where we raised state court challenges, because typically states, not EPA, issue these permits, we were unsuccessful and got 2 very poorly reasoned, insubstantial opinions, just generally deferring to the agency's approach to this industry. So I decided we really need to find a federal forum. And there are only a handful of states where EPA has not delegated the permit program to the state. And there's only 1 state when I was doing this that was in the 9th Circuit. So I thought Idaho, when the next permit comes up, that's our best bet. And so we waited for the permit renewal, submitted comments on the draft, and teed up a 9th Circuit petition for review, which we filed with the help of Earthrise Law Clinic. And we got a great decision in September. Our 9th Circuit panel agreed that the Idaho permit lacked required monitoring for discharges, specifically through waste lagoons, and also from land application fields, which is really significant. So right now we're still working on this issue. We're going to be trying to ensure that EPA's permit revisions on remand are strong and that this doesn't end at the Idaho border and EPA and states begin incorporating real monitoring into CAFO permits across the country. So we have a long way to go, but this decision was an important step towards accountability and generating a lot more data on CAFO pollution. And the last matter I'll talk about has to do with those nationwide pollution standards I mentioned, which are referred to as effluent limitation guidelines. So also with Earthrise, we are challenging the adequacy of EPA's permit standards for the CAFO industry. These guidelines are the national technology-based standards that have to be incorporated into every NPDES permit. And the statute imposes a duty on EPA to review and, if appropriate, revise these standards every year. It has not revised the CAFO ELGs since 2008, and we think that they fail to protect water quality sufficiently for several reasons. They don't apply to all CAFOs. They don't cover all pollutants of concern. They really emphasize crop yield more than water quality. They don't prohibit dangerous practices like spreading on snow-covered ground, et cetera. So we challenged EPA's most recent decision not to revise these standards with Earthrise again in the 9th Circuit. And it kind of shows the interconnection between our strategies, but this case really underscores how important monitoring is to getting strong regulations in place. So EPA's review process for all of its industrial ELGs every year relies on ranking industries' nutrient loads and comparing them to each other to see which are the biggest polluters that they should prioritize. But where does it get the data for these rankings? From those discharge monitoring reports, which essentially don't exist for CAFOs at all. So this is kind of a classic garbage in, garbage out analysis, where EPA's data set shows that CAFOs basically don't pollute at all. So of course they end up near the bottom of the list, and EPA knows about this problem, but has done nothing to fix this flaw in its approach year after year. Now, we think that EPA probably knew it was vulnerable on the merits of our challenge, and it sought remand without vacatur so it could get another bite at the apple to defend its position. And unfortunately, last month, the motions panel in our case granted remand over our objection. But we've already commented on the next iteration of this annual process, which again signaled that EPA is not likely to revise the CAFO ELGs. And so we might have a new opportunity for a case in the future. And in the meantime, our case is not completely dead. EPA has to provide 90-day status reports on remand. So we will have future opportunities to pursue stronger ELGs through both of those avenues, but also through our petition for rulemaking. And I'm guessing I'm about out of time. So I just want to say, this is really long-term work to fill huge gaps in implementation of some of our bedrock laws. I think that's the case with a lot of animal law, where we're just really behind the 8 ball trying to create regulatory protections that should already exist, but simply don't. And so I thank you all for having me today and wish us all luck in moving the ball forward and persevering.
That was awesome. Thank you so much, Tara. It sounds like an absolute uphill battle, but one that I would argue has a pretty promising future. So thank you for
Thanks.
sharing all of that. All right, up next we have, and please correct me if I'm pronouncing your last name wrong, Amy Von Sun. Amy is a senior attorney in the Center for Food Safety's Portland, Oregon office. After clerking for CFS in law school, they joined CFS as an attorney in 2015. As part of CFS's legal team, Amy practices environmental and administrative law to defend farmers, communities, and the environment from industrial animal factories, aquaculture, genetically engineered crops and animals, and the overuse of toxic pesticides, especially in the Pacific Northwest. Amy also works to protect the integrity of organic and ensure the transport labeling of genetically engineered foods. Transparent labeling. A 2011 graduate of Lewis and Clark Law School, Amy has focused their legal education and career on public interest, environmental, and food law, earning a certificate in environmental and natural resources law as well. Prior to joining CFS, Amy has served as a volunteer attorney with Earth Justice, working on animal factories on the East Coast, and then litigated complex environmental insurance cases at a law firm in Manhattan. Amy is also admitted to the bar in Oregon and New York. Congratulations, that's awesome. So without further ado, I would like to introduce all of you to Amy, and feel free to take it away.
Thank you, Kat. I should clarify that I had passed the bar in New York, but I have since let my membership lapse. So technically, I'm not going to be bringing any cases on your behalf in New York anytime soon. But it is my home state originally. So thank you for that introduction. And as Kat said, I'm Amy Van Son. I'm a senior attorney at Center for Food Safety. Let me see. I'm assuming my screen share is working. Oh, it's in presenter mode. Okay, let me figure out how to fix that. Did that fix it? Is it?
Yes, that looks awesome.
Okay. Huzzah, I did it. Okay, great. So that's my happy bee slide there. Center for Food Safety is a national nonprofit that has about 1 million members nationwide at this point, and our mission is to empower people, support farmers, and protect the environment from industrial agriculture and the industrial food system. So as my bio mentioned, this includes a lot of different programs. Basically anything that touches food is something we might work on. We do a lot of work on animal factories or factory farming. That includes aquaculture, or the CAFOs of the sea, and protecting the integrity of organic food, specifically as to livestock. So those are the 3 areas I'm going to touch on today. So first of all is our animal factories work. And I think Tara did a great job of giving a rundown of why these are problematic and what the major Clean Water Act regulation is there. So a lot of our work is national in scope and impact, but I'd say most of our CAFO work tends to be on the West Coast. So Washington, Oregon, California, and Hawaii, both in directly addressing facilities that are polluting and in trying to shift the regulatory system towards better regulation, like what Tara was speaking about. So in Washington, as you can see from this infographic we created a number of years ago, cows generate a lot of waste there. Similarly, in these other states, not so much Hawaii, thankfully, but in Washington, about 1/3 of all the cows that are in the entire state are actually concentrated in one place, the Yakima Valley, which is rural, eastern part of the state, lower income, large Hispanic and Latinx population, as well as near Yakima Reservation tribal folks. So it's a pretty non-surprising for anyone who studies these issues that a lot of CAFOs get cited there. And the community for decades tried to get help from the state and from EPA because of nitrate contamination in their well water. So a lot of people are on wells out there, and there was, in addition to the water contamination, of course, like the smells and the other problems with, waste being sprayed everywhere from these CAFOs. Finally, EPA did do a study of the wells and found that a lot of them, most of them, especially all that were downstream of these facilities, had really high levels of nitrates, which are colorless, odorless, flavorless. So you don't know if you have them in your water unless you test. And the only way to take them out is through a good filtration system. So you can't boil them away. That in fact concentrates them. And they've been linked to all sorts of health problems. But probably the most well-known is the blue baby syndrome, because nitrates affect the blood's ability to carry oxygen. They also have been linked to cancers, other reproductive and cardiovascular problems, just a whole host of bad things. We get them, of course, from a lot of sources like our food that we eat, but these were really high levels and they were in people's drinking water. The study EPA did also concluded that this was coming from the dairies, which is a pretty astounding thing that scientists will actually say, like, yes, we're sure that this is where it's coming from. So it was a really good factual base for us to bring a case along with, and you can see this is the first case cited, CARE, or the Community Association for Restoration of the Environment. They, for decades have been doing this work in the community. Center for Food Safety was also a plaintiff and co-counsel in that case. And it was the first case that we sued a number of these dairies, a cluster of them, that used RCRA, the Resource Conservation and Recovery Act, on the generation, transport, and storage of solid and hazardous waste, and used that against the dairies to say, look, when you're spreading all this waste on these fields, it's not fertilizer. When it's higher than the rate that the plants can actually use, you're dumping it like waste. And so this was the first test case for that. And in 2015, the Eastern District of Washington, the judge did agree that this was waste, this was be considered solid waste, and that its spreading was causing a substantial and imminent and substantial endangerment. I forget the exact language, but point being that there's this great part of RCRA that lets citizens sue if a facility is endangering public health or the environment from their waste. So we have RCRA applied to CAFOs. Cow Palace was sort of the first case in this cluster in 2015, and we've been able to build on that ever since. And now, I don't know if the exact number, but I believe it's a third of all the cows in the Yakima Valley are under a consent decree, because after that summary judgment motion, that order came down in 2015, there was a big settlement with all of the dairies in that cluster. And it said, included measures like having to double line with synthetic liner your lagoons, so they're not seeping into groundwater that way, and to do water quality monitoring, this kind of monitoring that Tara was talking about on the fields. And so to ensure that you're not overspreading waste on the fields. And so with that as a template, we've now brought many other cases against dairies in the area. And again, I said, I think about a third of the cows there are under a consent decree that we've helped to do. And a lot of credit there goes to Charlie Tebbett and his law firm. So definitely want to shout out to him. I'm sure many of you know him. So that was that sort of industry track of doing this. And the point here is the more dairies we get under a consent decree, one, now there's an enforceable court order saying you must make these improvements, but also it shows this is now becoming the industry standard. So if you're not getting on board with this is technology that exists, that is feasible to use, then you're not doing as much as you should be. So now the goal is to take that and make it statewide. Well, more than statewide, but so moving to kind of our permit track, that's the second case that I have listed. This is the recent win we had. The court, so we sued the Department of Environmental Quality, or Department of Ecology, excuse me, Department of Ecology in Washington, when they came out with this totally lax general permit that only covered really a handful of dairies under the state law and the NPDES permit under the Clean Water Act. And so we sued on that. It was us and a number of other groups. Puget Sound Keeper is one of them. And challenged the state permit at, of course, you have to go to this board, the Pollution Control Hearings Board, which is, as Charlie called it, a kangaroo court that basically just exists to uphold what the agency did. But then we go up to the Court of Appeals, and that in last year was our win. And so that's that second citation on my slide. The court in this case said that the permit has to have all known and reasonable technology basically to stop the pollution, and that was not satisfied for the manure lagoons or the compost areas, that the permit had insufficient water quality based effluent limitations and insufficient groundwater monitoring, that it did not and should have had public comment on site specific nutrient management plans, where it is, from the general permit now of facilities saying, here's how we're going to actually specifically fulfill this. And also that the department needed to consider climate change under the State Environmental Policy Act, SEPA. So it's a great win. It's along the lines of the Ninth Circuit case that Food and Water Watch brought, that Tara just spoke about. And so the idea is to continue to build this good precedent in the state. Now, of course, we're back at the permit reissuance phase, and we're doing a lot of advocacy there because we have pretty big concerns that the Department of Ecology is just going to draft another bad permit and not actually do all the things that the court requires and really make the big structural changes it needs to make. So whenever you win in court, there's still more work to be done after that. So that's where we are there. Next, I want to talk about our work in Oregon. Try to be a little brief here because I know I have like a lot of different things I want to cover. But the Stand Up to Factory Farms campaign, here's some imagery from that. Food and Water Watch is also a major part of that coalition. And the goal we have is to get a moratorium on all new or expanded mega dairies in Oregon until the state can actually protect our air, climate, water, community health, and animal welfare. So this is a coalition of local, state, and national organizations that have a very diverse array of interests, including animal welfare, environmental protection, supporting regenerative agriculture and independent farmers, public health, and climate protection is a big one. So we have, so we define mega dairy as 2,500 or more cows. And, the federal definition of large dairy is 700 cows. So this is much bigger than that. There are already about a dozen of these facilities that are 2,500 or more in the state, but the largest by far is 3 Mile Canyon Farms, which is located in Boardman, Oregon, and is permitted to have up to 90,000 animals. So we're talking about orders of magnitude larger. Our campaign was successful in helping to shut down the second largest mega dairy, Lost Valley, which was permitted for 30,000 cows. Now, our coalition came together around Lost Valley when it was proposed. It was unfortunately permitted and then immediately racked up over 200 violations of its water quality permit, but the state shut it down at our urging, and so far the site has not been reopened, although it has been purchased by a farm family that is now very infamous called the Easterdays from Washington. And I don't think I have time to get into that, but please check out our website. You'll see all this information. Basically, our campaign is as a legislative initiative. So here we're trying to get a bill introduced. We're trying to pass a bill that would enact this moratorium. We've already successfully had bills introduced in the last 2 long sessions with hearings, and now we're looking forward to the next long session in 2023. The challenge here is that despite having a super majority of Democrats and a Democratic governor, agriculture tends to bring the R out in the Ds. You get a lot of folks who may seem progressive, and then when it comes to farming, or even what we wouldn't really consider this farming, it's an industrial activity, they turn right around and seem to turn into Republicans. So a lot of our fight is against that and the narrative that size doesn't matter and that our current system is working just fine. I see mega dairies create mega size pollution. So size does matter because some of them are so big that when there's a problem, it causes really major issues. And our system did not stop Lost Valley from being opened. It also doesn't stop mega dairies from polluting climate, their local air or water quality, or from drawing massive amounts of water for their operations, especially in these eastern parts of the state where there's drought and our fresh water sources are dwindling. So of course it also does nothing to prevent the harms to animal welfare from this confinement type of dairy. So we have a ways to go there, but we have had some successes. And this is sort of, I mainly do litigation. So this is like the other hat to put on of, well, when our laws aren't good enough, we really got to pass new laws. So let's hold our electeds accountable to do that for us. Those are long-taking campaigns. So aquaculture, I'm going to talk about this in 2 slides, and then I'll wrap up with organic integrity really quickly. Aquaculture, we call them the factory farms of the sea. Unfortunately, this is something that's been seen as benign and really pumped up as necessary to have more fish products to feed us, but it is just taking its cues a lot of the time from our factory farm system on land. So we have been trying to address this, and so has Food and Water Watch, another shout out there. In that first case listed, the Gulf Fishermen's Association, we were successful in fending off offshore finfish aquaculture. So big nets, like you can see in this picture at the bottom, large floating nets or cages in our federal waters. So that's 3 to 200 miles offshore. So not state waters, but federal waters. Currently, there's no system in place for that permitting, and NOAA decided they wanted to create one and did it using the Magnuson-Stevens Conservation Act, which regulates fisheries that are wild, not aquaculture. And even though we were in the 5th Circuit, the district court agreed with us that they exceeded their authority that was granted to them by Congress, and the 5th Circuit upheld that, which was a really great win. Now we are still, of course, trying to battle because there's no permitting in place, like no big system in place, but that's sort of now the Wild West. So we have to, keep watchdogging and probably bringing more litigation to ensure that our federal waters, which are home, as I'm sure you all know, to lots and lots of wildlife and endangered and threatened species, keep it free from this industrial activity. We also had success in challenging the first ever GE fish approved for human consumption. And there, while the court did not actually vacate the permit, a drug approval by FDA, we did succeed in getting a better and more meaningful assessment of impacts to the wild salmon that are highly endangered wild Atlantic salmon, should these GE salmon escape their confinement. And FDA is still working on that. Of course, this win was in 2020, and we recently filed a FOIA lawsuit because it's been a long time and we asked for some documents and they said it would take 2 years to get us our documents. So we just sued them this week. Finally, this is the challenge part. Like I said, so the offshore stuff is we're still winning more than not on that, but the state waters, there's a lot more aquaculture. And recently we lost a challenge in the Washington Supreme Court for challenging Cook net pens, Cook aquaculture. They had net pens that were stocking Atlantic salmon, and then they had a huge breach, and 250,000 non-native salmon escaped into Puget Sound. Washington people pressured the legislature, and they did pass a law saying no more non-native fish farming, but they didn't go far enough. And so now Cook is just going to restock with native steelhead. So we got a bad district court opinion that just deferred to the agency. We appealed to the Supreme Court. It took our case, but then it affirmed and found that this agency did not violate the state environmental law or other water protection laws. This is despite the fact that potential impacts to native steelhead might be even worse than impacts from farming non-native fish, because there's an increased risk of disease transfer. Of course, if you're, the same species of fish, you are susceptible to the same diseases, and, risks of competition or genetic introgression from escapes. So the problem was that, the agency was comparing this to having Atlantic salmon in net pens rather than no aquaculture at all. So the state-based challenges can be quite difficult. Okay. Oh, we're doing good on time. Thank you. So that's some of our aquaculture work. Within that is our shellfish aquaculture work. Now, here is a form of aquaculture. This is farming bivalves. So shellfish in general would include crustaceans, and that's mostly in like Southeast Asia, and that's not what I'm talking about. We're talking here about bivalves, so oysters, clams, and mussels. And Washington State is has a very advanced industry for this. It's been farming oysters and other bivalves for over 150 years because it was home to the native Olympia oyster, also present in Oregon. And during the gold rush times, a lot of white colonizers came in and over-harvested the Olympia oyster, and so nearly to extinction. And then they decided to start growing oysters instead. So they imported ones from Japan, and now the Pacific oyster and other varieties that are similar are farmed. Now, you might have heard that this is a benign type of aquaculture, and it can be, because they're filter feeders. You don't have to dump a lot of feed into the water like you do with finfish aquaculture. You don't have to harvest forage fish to feed your carnivorous finfish. And the animal welfare concerns are quite a bit lessened, but I do want to touch on this because there are impacts to wild species from this type of farming, especially when you use a lot of plastics and pesticides, which putting into water is a terrible idea because we already have a big problem with marine plastic and pesticides getting into water. So that was something we kept hearing from our members in the area. That's one of our members, Ross, there I'm posing with on his tide lands in Willapa Bay. And we heard from our members saying, like, they're putting herbicides on the eelgrass. They're using all this plastic, like, this is terrible, you need to do something. So we looked into it, and the state was a no-go because the state is very supportive of shellfish aquaculture, and they get a pass on basically all of the rules. And even when there's like some local approval that has to happen in terms of complying with the shoreline management plan, they still it's very, very difficult, if not impossible, to stop any of these operations. So we looked for a federal angle, and the Army Corps of Engineers is responsible for the Clean Water Act, Section 404. So the dredge and fill part of the Clean Water Act, and also the Rivers and Harbors Act, which governs structures in navigable waters. So we looked at what the Army Corps did, and it has been issuing these nationwide permits, which are a general permit for the whole country since about 2007 for shellfish aquaculture. Now, while this permit is nationwide, it's used like 98% in Washington. So basically it's a Washington general permit, and their environmental assessment was just god awful. It was not good at all. They did not take into account the cumulative impact of having, it's a quarter to a third of all of the tidelands in Washington have some aquaculture already happening on them. And so you can see from these pictures, these tubes are gooey duck, and they stick these PVC tubes into the sand at a rate of 42,000 an acre. Then they cover them, they put the little gooey duck seeds in there, and then they cover them with netting. And so this is an aerial photo of all the netting that happens. And it's a little hard to see without the outlines, but it's the whole area that has this plastic net over it. So we're talking about entanglements of wild species, being, be unable to access their food and habitat. These are areas where there's, forage fish are breeding, and then, fish like wild salmon, juvenile salmon might, the estuary areas, they're going to come and they're going to eat and stuff before they go out. And then of course, those salmon are also food for orcas. So it has all these rippling impacts throughout the food web to wild species, from putting all this plastic and in Willapa Bay using pesticides on these operations. So we took the Army Corps to court. We had NEPA claims, we had ESA claims, Clean Water Act claims. We won last year, 2 years ago, on the NEPA claims and the Clean Water Act claims. Very basic, like, there's more cumulative impact than you have. You haven't properly looked at the cumulative impact here. The Clean Water Act does not allow you to issue a big general permit like that if it's going to have more than a minimal adverse impact. So go back, Army Corps, and justify that. And we actually got the permit vacated, which was great, with a little exception, for people that already had shellfish in the ground, that you could harvest those. And they did get one more planting season, although we did object to that. But it was a balancing of, like, we're not going to shut people down, and COVID was happening and all this. So, but it was still a great win. And, there's been a couple of cases of taking down these nationwide permits because there are over 50 of them. There's like oil and gas pipeline stuff. It runs the gamut of all the things that are dredge and fill, but this was the first one having to do with aquaculture. The industry appealed to the Ninth Circuit, and that was actually my first Ninth Circuit argument, and we won, and that was really great. So the permit is still gone. Now, of course, the challenge part, which is that the Army Corps came back and reissued its nationwide permit in 2021, right before the end of the Trump administration, and did an even worse job at assessing the cumulative impacts and doing the environmental review. So we're back in court. We just filed that lawsuit in December of last year. And there's a whole bunch of other tricky issues with, they issued a bunch of individual permits and did that in a way that we think is unlawful, but basically that's where we are with that. So I have just one more thing to touch on. Am I good on time? Okay.
Oop, sorry, just hit the button. Yeah, you can go for like another minute and then we'll wrap up so the other speakers can hop in. Thank you so
Great.
much.
Great, yeah. Okay, cool. So we got through aquaculture, protecting organic integrity. So for, I don't know how much folks here are, familiar with the organic program, but generally consumers, especially like many of us, expect that organic animals had humane living standards and were treated well. And there are regulations that require that say, access to outdoors and sufficient space and natural behaviors, which are great, but the devil's in the details. So USDA, after 10 years of rulemaking, came out with the Organic Livestock and Poultry Practices Rule right at the end of the Obama administration, which put a lot of details in for all livestock, but especially closed a loophole for hens and broiler chickens that would stop allowing concrete enclosed porches to be considered outdoor access and required a lot more space for them, among other things. So it was closing a loophole. This sort of the reason why organic eggs could be $3 a dozen. It's not right. So it was unlevel playing field with producers who were doing it right and giving their hens good welfare, and producers that were basically factory farms with organic food. So we challenged that rule with Trump came in, don't want to get ahead of myself, withdrew that rule for very ridiculous reasons. We sued right after that. It was 2018 and litigated it for 4 years. Unfortunately, we just lost that case in that the agency has said, well, we're Biden now, so we're Vilsack again. So please let us take the rule back. We're going to fix it. And the court said, okay, you can go fix it. We're not going to rule on the plaintiff's claims, although he did say we would have won. So I'm very frustrated by this new trend of using voluntary remand to avoid a judicial order. But the good news is that USDA will be hopefully reinstating either this rule as it was written or an even better version in the coming months. And so I know I'm over my time. Just want to thank you so much. I'm excited to hear questions later.
Yeah, definitely. Sorry to rush you there at the end. All of that work sounds amazing, and I definitely want to ask you some questions. All right, moving on to our next speaker, I'll be introducing to you Marie Camino, who is a policy advisor at Mercy for Animals. There, she works on state and local legislative and regulatory issues. And previously, Marie worked on human services issues at the federal level, focusing primarily on regulatory work. Marie holds a master's degree in public policy from the University of Florida and has been part of the animal movement for more than 9 years. So without further ado, feel free to take it away.
Thank you so much. Can everyone see my screen okay? Yes, perfect. So I'm going to start by showing you all a really quick video. I think it does a good job of giving you an overview into what I think is a little bit of an esoteric issue. So without further ado, I'll start that. Great. So I think everyone kind of got, a brief overview of the policy that I'm going to be talking about today, but I will kind of give you a more general overview. So I will be focusing on just one policy that Mercy for Animals pursues. Right now, it's primarily at the state and local level. Hopefully in the future, it will be at the federal level. So just a general overview of the policy. Let's start with the problem. So as you saw in the video, the issue is that governments basically prop up big ag in part by using taxpayer dollars to purchase meat, dairy, and egg food products. So what would our ideal solution be? Our long-term vision is for a plant-based food system in which governments use their purchasing power to procure only plant-based food. So how do we get there? Since early 2020, Mercy for Animals, alongside a ton of other organizations, has been active in advancing different types of policies that aim to shift government purchasing. And so far, we've identified about 9 policy avenues to accomplish this goal, primarily to accommodate, all types of jurisdictions and what is politically feasible in those jurisdictions. Ultimately, we have identified procurement or purchasing policies as some of the most effective for removing farmed animals from the food system. And some of these policies are more politically feasible than others, as I mentioned, and we're being strategic in our approach as far as what jurisdictions to try certain policies. So just kind of an overview of, the meat and potatoes of the policy. These purchasing policies first require governments to create a measuring methodology that doesn't exist yet. So it's kind of a big ask. They task the city or state's environmental department with establishing a baseline of greenhouse gas emissions associated with the food that the government purchases. This requires measuring and tracking emissions, associated with the life cycle of food. So what do I mean by the life cycle of food? When we talk about the life cycle of food, we're talking about the emissions created from cradle to grave of a product. So we're looking at the cumulative environmental impact that a food product has. So just an example, if governments are purchasing chicken nuggets, the life cycle of those chicken nuggets include the emissions that generated by the living animals on the farm, for example. Also things like the transport trucks going from farm to slaughterhouse and from slaughterhouse to distribution. So we've really tried to take a holistic view of what emissions are being created when creating these foods. So measuring and tracking these emissions presents significant opportunities for states and cities. In addition to measuring and tracking emissions, the legislation tasks governments with establishing a baseline measurement of overall annual emissions from food purchasing, and then a set of best practices to reduce those emissions, along with recommendations for reducing the purchasing of animal-based products specifically. So that is a big part of the legislation that Mercy for Animals authors. So where are we working on this? This can have different impact based on where we choose to work on this. So at the local level, for example, this encompasses purchasing for things like the cafeteria at City Hall. It could also include publicly funded food programs, things like for seniors, and just any city-owned facility. Sometimes this could include schools. That would make it a much bigger impact. But this does change with every locality since every local government is different. But in general, municipalities often have large multi-year contracts, and this tells suppliers that they need to offer plant-based options. At the state level, this can encompass state buildings like the Capitol, but in some cases can include hospitals and correctional facilities, which makes the impact even greater. These contracts are even larger and way more coveted by suppliers than even the municipal contracts. And then of course, at the federal level, these are very large contracts, very large impact. It would really depend on who decided to take on this policy. If it were the Department of Defense, for example, that would have huge impact. They are one of, if not the largest purchaser of food in the country. So that tells all of their suppliers that you need to be offering plant-based options. So who does this impact? Obviously, there is a big impact on animals. So with, these policies, it would reduce the number of, meat, dairy, and egg products purchased by governments. So with this reduced demand comes, sparing of animal lives. It also impacts the environment. With less demand for meat, of course, comes fewer harmful emissions, less deforestation to raise animals and their food, and less water consumption overall. This really depends, though, on what they switch to. So we are working with our internal research team to develop, some data to know the differences between alternatives, because obviously there will be a difference if a municipality wants to, switch to a more environmentally friendly food and they switch from beef to chicken. That will have a lesser impact than if they switch from, beef to a plant-based product that is not quite as resource heavy to create in the first place. And that will be kind of a big talking point when we speak to legislators. Of course, it will impact human health. So purchasing foods with lower greenhouse gas emissions could mean less red meat and dairy offered to residents who receive public meals. And I'm sure, as many of us are well aware, diets higher in plants and lower in animal products have been linked to a reduction in heart disease, which is, the #1 killer across the country. And finally, equity. If any of you attended my colleague Shayna's talk earlier in the day, she did a great job, but she did touch on this a little bit. So in Washington, D.C., excuse me, they passed one of the first climate-friendly procurement laws in the entire country. And DC's Office of Racial Equity's impact analysis actually found that greenhouse gas emissions and air pollution disproportionately impact Black residents, and that the new law could potentially improve health outcomes for Black residents in the district. It also indicated that Black residents faced higher rates of chronic diseases, things like asthma, diabetes, cardiovascular disease, and that residents facing food insecurity and those living in DC facilities like correctional facilities, as I mentioned, were most affected by changes in foods offered by district agencies. So when these policies encompass things like correctional facilities, that can increase the health of the incarcerated and health equity overall. And for this reason, the NAACP has supported a procurement bill similar to the ones that we work on in Maryland for its impact on racial equity in this way. I would also like to note that sometimes this could increase cost savings for a municipality or a state, depending on what they switch to. So there was a similar policy in the Oakland Unified School District in California, where they actually found that they saved $42,000 over the course of 2 years. So this, of course, when you're speaking to legislators, is going to matter a lot more, unfortunately, in many cases, than the impact on animals, the environment, human health. They're often most concerned with taxpayer savings. So this is a big feather in our cap that this could, reduce the amount of money that a state or local government spends on food each year overall. So finally, our legislative strategy. So beginning in the year 2024, Mercy for Animals' hope is to be in a position to begin scaling these up. So by this juncture, we hope to have multiple plant-based food policies in effect in multiple jurisdictions. Legislators can sometimes be really hestant to pass a law that has not been done elsewhere. So, the more places that do it, the better chance they have of being passed somewhere else. When a law passes in one jurisdiction, others are more likely to follow, especially depending on, where it was passed. So our strategy with this is very similar to the marriage equality movement, the way that they did their strategy. They centered their scaling strategy on what's called a 10-10-10-20 strategy. So by the year 2020, they wanted to have 10 states with marriage equality, 10 states with civil unions deemed comparable to marriage equality, 10 states with domestic partnerships or other limited protections, and 20 states where public opinion moved in the right direction. So that does kind of account for, some less progressive states. And the overall goal is to change everybody's mind, slowly but surely. So for this, we'll identify states for our most, ambitious plant-based food policies and work down our list of options, kind of the 9 policy options that I mentioned before, from there. So ultimately, the goal is to introduce a federal bill modeled off, some of our most impactful state level successes once the momentum is there to support such an ambitious bill. So if we did this at the federal level, this could encompass a ton of federal agencies that provide a ton of public food for people. So thank you all so much. I look forward to hearing your questions.
All right, awesome. Thank you so much, Marie. That was really cool to get the groundwork idea of what you're planning for the future. It makes it feel possible. All right, last but not least, I would like to introduce all of you to Erin Sutherland. Erin is the staff attorney in the Farm Animal Department at the Animal Welfare Institute. At AWI, Erin focuses on regulatory, legislative, and legal affairs relating to the transportation of farmed animals, marketing of farmed animal products, and government transparency. Before working at AWI, Erin clerked at the Washington, D.C. public interest firm Meyer Glitzenstein and Eubanks, now Eubanks and Associates. Erin graduated in 2016 from Lewis and Clark Law School with a certificate in environmental and natural resources law. Erin currently resides in Portland, Oregon with her husband and her rat terrier, Pendleton. All right, thank you so much, Erin. Please take it away.
Thank you so much, Kat, and thank you so much for inviting me to speak today. I really appreciate the opportunity. I'm going to speak a little bit about food labeling, why it matters, and how the USDA is harming small and sustainable farmers. Just a little bit about the Animal Welfare Institute. We're a national nonprofit dedicated to alleviating suffering of all animals, including those on factory farms. And as part of our mission, we look to support small, independent family farmers. All right, so to start off, I want to talk a little bit about why labeling is important to sustainable and high welfare farmers. It's AWI's view that deceptive marketing on meat and poultry products is a major threat to the future of high welfare and sustainable agricultural practices here in the US. And this is because producers who don't improve their standard of care are able to participate in the exact same markets as producers who actually improve their standard of care. As you can imagine, this harms animals, consumers, the environment, and obviously farmers. And to give a little bit of background about this, farm animal practices are extremely varied, but the vast majority of animals are raised at the lowest level of animal care and with the least amount of environmental protection. Only a small percentage of farm animals in the US are covered by any protective legislation, and consumers know very little about practices or how to distinguish between products. To them, chicken is chicken, and it's really difficult for them to tell the difference. Small farms obviously have very limited options in distinguishing their products because of this, and one of the only ways that they can do that is through marketing and advertising. So I'm going to give you a little bit of information about the legal landscape here. The Federal Meat Inspection Act, the Poultry Products Inspection Act, the EPIA, the FFDCA, all of these acts prohibit deceptive labels and packaging. Packaging cannot be false or misleading in any particular, as is what the act usually says. If the package is determined to be misleading by any of the overseeing bodies, it can be withheld. You can see this in FSIS's regulations. If they determine a product packaging is misleading during the inspection process, they can withhold it from the market, although I'm not aware of any instance where this has occurred with misleading animal raising claims or environmental claims. And I'm about to get into a little more specifics with respect to that. So you can see here how the USDA and the FDA divide their responsibility under these statutes. The USDA divides in between two different departments. They've got the Food Safety Inspection Service, which I mentioned earlier. They oversee meat, poultry, and processed egg products. So the AMS covers voluntary labeling issues. So shell egg grading, you might have seen like eggs graded as A or B, organic program, and the PVP program. The Food and Drug Administration oversees everything else, and with respect to animal products, they oversee shell eggs. You can see there's some duplication here between USDA and FDA there, fish and milk products. And USDA and FDA cover these, their responsibilities a little bit differently here. FDA does not require any sort of pre-market label approval for claims on product packaging, but USDA does to a certain extent. So like I mentioned before, FSIS requires pre-market label approval for claims on product packaging. There are two types. There's generic, and then there's sketch approval. Generic doesn't actually require any sort of interaction with the federal government, and the label is viewed as approved because it's in compliance with federal regulations. I know that this is really odd, but that's how it is. Sketch is where the USDA actually requires a producer to submit documentation for the use of certain types of claims. And we're going to talk a little bit about what types of claims require pre-market label approval. You can see these cute little pigs here. So here's some examples of things that require pre-approval. And what's most relevant to us are special statements and claims. And relevant to small sustainable farms that have humane practices, I think the top two are the animal raising claims and environmental claims. And these are claims like humanely raised, humane animal care, sustainable, environmentally friendly. You've probably seen them on product packaging. USDA achieves its oversight through this guidance document. You can see the really tacky looking cover here on the right. That's USDA's guidance over how it implements its special statements and claims requirements for approval. This is pretty inadequate in my opinion. You can see there's only 4 components that a producer would have to submit in order to use a claim. Number one, the biggest problem I see here is that even though there's this definition requirement, because these claims aren't defined in regulation or in guidance or in legislation, producers are allowed to define the claims themselves. And USDA thinks that that's just fine as long as they put that definition on the package itself. It doesn't really matter what the definition is. So producers just kind of can do whatever they want, and there's no real requirement that even the definition is relevant to the claim. The other ways that this is inadequate is, it focuses mostly on tracing, proving that the animal on the farm is the same one that is being slaughtered, and obviously that's relevant. But it doesn't really do much to make sure that the producer is actually taking actions to improve animal care or to improve its environmental production practices. So it's pretty producer interested minded. And when I say that, I mean, the lowest of the low industrial animal agriculture, not, your family farms that are actually trying to improve animal care and environmental stewardship. I'd also say it lacks quite a bit of specificity, and it allows producers to substantiate claims with really bad documentation. So they can submit an affidavit, they could substantiate a humane claim with the organic program, which, as you guys might remember from Amy's talk earlier, there aren't really any substantive standards under the organic program for animal care. So it's really hard to say that actually substantiates a humane claim. So it's pretty problematic, and this is how it plays out AWI has surveyed nearly 100 approval files over the past 10 years. The claims that we've been looking at include humanely raised, sustainably farmed, ethically raised, these special statements, not claims like natural, things like the ones that I've mentioned here. And 58% of these claims have absolutely no documentation for them. And what I mean by that is that the USDA did not turn over a label approval file for us for that claim, or that there was nothing in the file that is at all relevant to the claim. So in some cases, I saw sustainable, and the substantiation was something like antibiotic free. And obviously that's not necessarily a substantiation for sustainability. It's much more complex than that. And then for the other 42% of claims, there was at least some substantiation, but I'd say that this varied like hugely. So producers submitted anything from affidavits that were 1 page to operational protocols that were 1 page or 5 pages. But in reality, most of these producers complied only with basic industry standards for animal care or environmental stewardship. And this is a huge problem for sustainable farms. And this is also a huge problem this is also a huge problem because it's inconsistent with consumer perceptions for claims like these. So I'm including some information here that relates specifically to the claim humanely raised, but the vast majority of the public believe that claims like humanely raised means that the producer has better animal care standards than conventional. And this is inconsistent with how the USDA is approving these claims. Like I mentioned before, most of these producers only comply with industry standards. Consumers also really don't like the fact that producers are allowed to define these claims themselves. Obviously, it doesn't help with consistency. And then consumers also believe that on-farm verification is necessary, but obviously this isn't happening because it's just a desk audit of files that producers submit to USDA for assessment. So very inconsistent with consumer expectations and consumer desires. And so how is this playing out like with the animal advocates and environmental advocates? Here you can see 3 examples of labels that were approved by FSIS that were ultimately recommended for removal by the National Advertising Division. And this is a non-regulatory body that kind of mediates conflicts in advertising, but they work hand in hand with the FTC. So I think it's a really, really great forum for kind of mediating these types of issues. In all 3 of these cases, the producers substantiated their claim to FSIS using industry animal care standards. NAD found that they did not meet consumer expectations when they did that. So the first one you see, Animal Care Certified, was United Egg Producers certification. It's an industry standard, and they've had to change that label. Humanely Raised on Al and Harim was substantiated using the National Chicken Council standard. Obviously, that's industry. And then Ethically Raised, you can see, is a super long claim. They make this silly third-party animal welfare audits claim, but when we got the label approval file, they just are using the common swine industry audit. So FSIS is really acting inconsistently with even what the NAD thinks of as what consumers want and need. And here's some examples of other efforts that animal advocates have brought before the FTC and via litigation. There have been dozens, if not hundreds, of legal challenges to claims that are believed to be misleading that were approved by FSIS or which exist in the marketplace regardless of whether FSIS approved it. They have jurisdiction over it. Many of these cases don't reach review, however, because they are settled. And I think that's great if the claim is removed, or if the animal care or environmental production practices are improved. That's great. And unfortunately, if a case isn't settled, a common problem faced by litigators, especially in state court, is that the court finds that the actions are preempted by the PPIA, FMIA, or the EPIA, even when there's a state consumer protection statute that is on point. So I think that this is a pretty promising area for development, as long as courts can learn a little bit more about preemption and maybe get a better idea of what FSIS is actually doing here. And I'm going to go to my next slide, where I'm going to talk about a little bit about what needs to be done. Obviously, FSIS needs to stop approval of inherently misleading claims. You might be wondering how they can do that. They could, the simplest might be that they would define them either via legislation or through regulation. And I would say that this probably is not a good idea. Amy mentioned earlier that through legislation, you might find that even Democrats become a little bit Republican, and we've found that to be the case. Every legislator, especially senator, has some sort of ag in their state, and they don't want to see as opposing. They don't want to be perceived as opposing that. So it's really hard to define these claims via legislation. And even like-minded interest groups disagree. These are very complicated, holistic claims. So would USDA define them? I think that's also a terrible idea. USDA is, they perceive the industry as their customer, so it's pretty unlikely that they would define humane or sustainable as inconsistent with with industry production practices. I just find that it would be impossible. They can't tell the industry that what they're doing isn't humane or that it isn't sustainable. I just don't see it happening. So something that we think that could theoretically happen is that producers could be required to provide more substantiation for these high value claims, for instance, through the guidance document that I mentioned earlier. I think that one attainable way of achieving this is by requiring third-party certification. FSIS actually mentioned this in the past as something that they thought could be feasible. They're not as excited about it these days, though. But I do think that it's something that we need to be careful with. Third-party certification is now being co-opted by the industry. You can see there's several certification programs that appear to be legitimate, but then when you read the standards, they're merely industry standards. Sometimes they're even worse, which I think is really sad. It's a real missed opportunity. So what needs to happen likely is that certification needs to be required for the use of these high value claims. It makes things easier for the agency, and they can require certification to a standard that is higher than industry standard. And I think that that will be a benefit to animals, consumers, the environment, and farmers alike. So on that note, I'm just going to wrap up my presentation. If you have any questions, you can feel free to reach out to me. Thank you so much.
Awesome. Thank you so much, Erin. That was fantastic. All right. So we are going to get started with the Q&A. Just a quick reminder, if anybody has questions, please feel free to drop them in the chat. Our first question is from Cameron, and it is for Erin Sutherland. And Cameron asks, what role is there for private certification entities such as the Global Animal Partnership? Are these groups having an impact on farming practices or on consumer purchasing habits?
That's a great question. I think that these programs are wonderful, especially when they actually use standards that are based in sound animal welfare science, and when they consistently update their standards. GAP is a really interesting program in that it has several layers and they are several levels, and that they invite individuals to join an industry standard and ramp up their animal care standards as time progresses. And I think it really helps bring more producers into certification and improving their level of animal care. So yeah, I think it's great. And I do think that it helps bring higher welfare products to consumers. You just got to be careful. There is some greenwashing occurring or greenwashing and humane washing occurring in these certification programs.
Great, thank you. All right, our next question comes from Tara and Amy, or for Tara and Amy, sorry. Do you expect the Biden administration through the USDA or the EPA to issue stronger regulations on some of the issues you discussed, or should we expect this to be the status quo for the next few years?
Well, what I discussed is a bit narrower, so maybe I can start and then turn it to Amy. I think, I was encouraged by some of our FOIA responses on our Clean Water Act petition to EPA related to factory farm pollution specifically. But those are career staff, and that doesn't mean that the political appointees are inclined to make this their issue. It's been discussed that Big Ag is a bipartisan problem, and it's really difficult to get traction on these issues because Democrats don't want to be seen as anti-farmer. This has been a struggle with, I think, environmental and animal advocates for decades and decades. But I think we are starting to make progress educating decision makers about the true impacts of this industry, the difference between family farms and Big Ag. I think some of the antitrust signals coming from the Biden administration are really encouraging. If they can do something about it, unlike the Obama administration, which started and then dropped the ball completely on holding Big Ag accountable for its monopoly and monopsony issues. So I think there is a growing willingness to recognize the corporate consolidation problems at the root of the problems stemming from Big Ag and how that's manifesting in all of the harms from this industry. But I think if we want stronger rules from EPA, we're going to have to force them to do it.
Yeah, and I would say for USDA, we have Vilsack again. So it was pretty disappointing that he was appointed as secretary, given that he's definitely like a Big Ag guy. And one thing with the organic that I wanted to, I could speak to that is what when they came back in, we thought, okay, they'll reinstate this rule that was very detailed. It was a decade of process with NOSB, which is the standards board that advises USDA on organic program standards, and lots of public comment and a lot of stakeholders like Center for Food Safety engaged in it. We were thinking, oh, they'll just, they'll reinstate the same rule. And they've said, well, we're gonna reconsider the, statutory issues and then reinstate the core principles of the rule. So we're like, what does that mean? Is it gonna be, could we make it better? So, we are trying to be optimistic that through there's a lot of organic community stakeholders and groups that can influence that rule to become even better, because there were a lot of things that were left out of it in 2016 2017 that we wanted to see in there, including standards like more specific to pigs. And I will say, though, I wanted to clarify one thing as to the organic program. And the reason that we focus so much on it is because it does have federal standards that are enforceable and, that has a lot of public process to them, unlike any of the other private certification labels. So that's why we're still sort of sticking with it and trying to just keep it like having integrity and being meaningful. And, that there are a lot of rules around animal care, especially for ruminants. In 2010, there was a pasture rule, access to pasture for cows and other ruminants. So it's just a matter of putting in the details that are lacking for the rest of the animals. So it's still better. I'd say organic label is still better than no organic label when it comes to animal welfare and animal care. But it still has a ways to go, and hopefully the Biden administration will do something about it. But I agree with Tara's assessment as to the EPA. I think both that there's still these intractable problems that we sued the Obama administration a bunch of times. So we try to be hopeful, but not have high expectations.
Great, thank you. All right, so this next question comes from Professor Reddy. He says, this question is for Aaron, but it's open to all. This is slightly outside the realm of humane label, so I appreciate if this is outside of your focus. But I know that there's a new One Health certified label that's been approved by the USDA. It mainly focuses on antibiotics. I know animal ag, in particular pork producers, have had a strong hand in creating the standards, but I'm wondering if you know if there's any litigation planned to combat it as misleading or otherwise. Thank you.
Thank you for your question. I'm not aware of any actual legal challenges that are in development for this label in particular. But I do want to mention that, One Health Certified obviously co-ops the legitimate One Health welfare movement, the global movement for animal and human health. So it's very important that we combat this. I know that there have been a lot of groups. I believe Tara, correct me if I'm wrong, was Food and Water Watch working on this substantially. But I know that there's only one major producer who's using this claim or certification. So luckily, it hasn't taken the hold that we really expected it to, because it is basically in codifying industry standards in a certification program. And this is exactly what I was talking about at the end of my presentation, that we need to be careful that certification programs as a basis for humane and sustainability claims actually improve upon industry, animal care, and environmental stewardship. So thank you so much for that question.
Great, thank you. All right, so our next question is for Marie. And this person asks, have you experienced any pushback from local governments not wanting to reduce their footprint through food purchasing and wanting to use other methods instead? How would you persuade them that this is the best way?
Yeah, that's a great question. We've received less pushback for that reason, mostly because a lot of municipalities or states have already, put policies in place to reduce their footprint by purchasing other things like cleaning products, for example. There's policies surrounding this. So in a lot of cases, we will target jurisdictions who have had that. And just encourage them to add food. That's kind of a great strategy there. So we haven't had a ton of that. We have had some jurisdictions, even really progressive ones, cities that you would think of, traditionally as very progressive, as thinking that this is government overreach. Some cities have expressed that they don't want to be part of determining what people eat, even if it is, public food programs. So that's kind of more of what we've seen. And we did do a big internal survey in jurisdictions all across the country to kind of get their thoughts on this. And that was, kind of the primary setback that we did see. So we're working on talking points, kind of debunking that. Because we are not, taking meat away from people. We are just providing more plant-based options. So that's kind of the bigger issue for us.
Great, thank you so much for answering that. All right, our next question comes from Ken, and they ask, for anyone, how does government subsidies impact the legal battle for farm animals? It seems the guaranteed revenue gives animal ag an advantage that the court can't touch.
I mean, the fact that so much of the subsidies go to, the corn and soy and the feed that's going into the industrial animal agriculture system, it just makes it seem cheap artificially, so that it's difficult in terms of the economic impacts to say, of the larger industry when you're in court, and say if you win and you're trying to vacate the agency action that was taken, courts will look at, what kind of disruption and what kind of consequences there'll be if they undo this thing the agency did. And so, these trade groups and companies will come in and say, the sky will fall because all of our affordable food will be gone, and they want you to eat all the really expensive, organic, high animal welfare stuff. And I mean, so that's a narrative problem that we can all help debunk, that, to show the true cost of that food. But, I think that's been ongoing work we've all done. When it comes to money in court, it's their lawyers might be highly paid, but we're really good too. So it's a pretty level playing field compared to the legislature. That's where the big money is just very hard to compete with. And that's why we need groups like Food and Water Watch to get all the organizers out there and create our people political power. But yeah, in court, it's a more level playing field, I think.
I would just add to that, that outside the courtroom, strictly speaking, a lot of these subsidies are really perpetuating this neoliberal idea that we should be allowing voluntary practices instead of regulation. This really anti-regulatory sentiment and culture has taken hold in our government, and we throw money at things instead of requiring industries to reduce their pollution, to increase their standards, to take care of their workers, whatever the case may be. And so, one emerging threat is just all the money being thrown around for false solutions to climate change, including factory farm biogas. So USDA is putting out a package for $1 billion package to support so-called climate smart agricultural practices, which are definitely going to include digesters. And if we ever want to regulate greenhouse gas emissions from this industry and try to, make regulation one of the ways that we drive this industry out of business, it's going to be really hard to do that when you're throwing billions of dollars potentially at technology that's only viable for the biggest factory farms, that makes them more profitable, that perpetuates our reliance on fossil fuels, separate issue, and that will just entrench factory farming further and make it more difficult to move our other legal and advocacy strategies forward.
All right, unless anybody else wants to jump in on that question, we have one last one for the group. All right, so this last question comes from Cameron. For the group, are you aware of federal or state efforts that offer tax benefits to farmers that utilize evidence-based animal welfare practices? Would anything like that have traction politically, or is it just a non-starter?
I can answer kind of. So I know that there are federal programs. There's some legislation that help producers gain certification for animal welfare. Also, there's some subsidies for improving practices or joining the National Organic Program, I believe. Or Amy, correct me if I'm wrong on that. I think you work a little bit more on organic than I do. So I don't know of any state level things, but definitely there are some federal efforts to improve sustainability in this way.
It seems like it'd be a good state-based effort. Because like Tara said, like the legislators are a lot more, they're a lot happier to say, yeah, we're giving money to farmers than they are to say, we're requiring farmers to do this. So, like here in Oregon, Friends of Family Farmers is a group that has done a lot of work on, in Salem, trying to secure, incentives to farmers to do the right thing environmentally. And so I could definitely see something like that being a potentially successful effort.
Yeah, one thing I will mention too is that a lot of the certification programs are quite low cost or free, though that doesn't cover the actual practices that you have to improve, so implementing high welfare practices or cleaning up your environmental practices costs money. And obviously that's why it's so hard for these high welfare farms.
I haven't seen anything like that at the state level either. I have seen a couple of grant programs aimed at helping farmers like that. There are also, there is a state bill in California that created a grant program to help farmers who, transition from factory farming into more sustainable farming, for example. And there was a similar proposal in Virginia that didn't get introduced this year because of, the results of the election there. So yeah, nothing that specific, but a few kind of, tangentially related pieces of legislation.
All right, it's 3 o'clock now, so I just want to say a big thank you and round of applause to all of our panelists. That was an awesome discussion. Super excited to just get more involved and keep on learning. So our last event of the day is coming up next. It's titled How Far We've Come with Jim Mason. And it'll begin in about 15 minutes. Go ahead, take a break, grab a drink, relax a little bit, and we'll see you back at 3:15. Thank you.